Tēnā koutou katoa, nau mai, haere mai. Greetings everyone. Welcome to our latest NZ Free Law podcast, brought to you by ture.co.nz. The purpose of the podcast is to assist with fulfilling Ture's mission, which is to connect New Zealanders with better access to and knowledge of legal services. So NZ Free Law talks all things law in New Zealand. And my co-host is Josh Brown. Hi, Josh.
Kia ora, curious Josh. I ask the questions that everybody's thinking, that when the lawyers speak in legal jargon, it's my job to say, what are you talking about?
Unpack that, yeah. So as always, it's good to have you here, Josh, as a non-legal person asking those questions. And my name's Julia Stenson. I'm a lawyer from the Waikato who's the founder of ture.co.nz and NZ Free Law. Now to our special guests of the day, Alana Thomas, who predominantly practices in Māori legal issues as a director at Kaupare Law Limited, based in Auckland, and joining us by phone. Tēnā koe, Alana.
Kia ora, tēnā koe. Ia koe hoki, Josh, o tira kia koutou te hunga whakarongo mai nā ki tātou kōrero. Kia ora.
Kia ora. And so can you tell us a little bit more about yourself, Alana? Just give us like a couple of minute introduction of who you are.
Absolutely. Talking about myself is one of my favourite things.
It's quite easy, isn't it?
So he uri tēnei o Taitokero. Ko Ngātire hia me Ngāti Kuri o Kuhapuru. I pakeke mai au I whangarei, I tāinei au I reira hoki. Engari I tēnei wānei e noho anau ki Tāmaki Makaurau. E rua ku tamariki, ko te ai o rangi, me mai oha. So I've been practicing for about just over 10 years now within the law. And I started up in Kaikohe actually doing criminal law and family law, but the majority of the work or the mahi that I do now is all from the Waitangi Tribunal, the Maori Land Court, and generally just issues that have Māori kaupapa at the forefront. So I have my own law firm now, quick plug for Kaupare Law, and I think the best thing about that is it's allowed me to really just do some of the claims and take on the issues that I want to, as well as allowing me to run some of my other passion kaupapas, which is the promotion of te reo Māori within the law system and within the courts. So koe tēnā.
Oh, that's awesome. And just on that, it's pretty exciting to see Justice Joe Williams being appointed to the Supreme Court.
Oh, it's amazing.
Yeah.
It really doesn't come as a surprise to us, though.
No.
Within the law world, he's been breaking those ceilings for how many years, and really has been at the forefront of making a difference and making a change within the law for Māori. So it's amazing that he's now one out of five, and he's Māori and really represents us and is at the forefront of all the challenges that we face for Māori within the law. So, yeah, it's amazing. E mihi ana te aia.
Yeah, it's exciting. All right, so we're going to move on now to the legal word of the day. So it's a part of the show where we introduce a legal jargon that lawyers are familiar with, but the public may not be. Now, today's words are, it sounds like straightforward stuff, but actually there's a legal element to it. Māori Land. And so my simple understanding, because I have not practiced in this area, is that Māori Land, that's my disclaimer, Māori Land is defined by the Te Ture Whenua Māori Act 1993 as being one of two things. And the first is Māori customary land, and that's where it hasn't had its ownership investigated or determined by the Maori Land Court, and it hasn't been acquired by the Crown, and it doesn't have a Land Transfer Act title or deed, and it continues to be held in accordance with tikanga Māori. And the other is Māori Freehold land, which is basically the opposite of all the things I just said. It has been investigated, and it has been set aside as Māori Freehold land by the Crown to a specific set of individuals, or it's been given status that's been determined as Māori Freehold land by the court, Maori Land Court. That's my simplistic view. So I'm welcoming any kōrero that you might have.
My mind's
Alana.
just being blown that there's different types of... Anyway.
No, that's interesting, Josh.
No, pai e nā whakamarama katoa ki au. Do you want to answer all the questions for this? No. No, that was really, really, really good. Basically, I think that if you could answer it easy, Māori land is land that's held by Māori. And I think we all probably know, because of our history, that's few and far between these days, what whenua we actually have in Aotearoa that's held by Māori. But yes, those two classifications are right. Māori customary land or Māori land that is managed by the Māori Land Court and is held by Māori. Yeah, pretty much it.
Great. Okay.
I still need some help with that, though. So, like, can you give me an example of, like, what would be Māori customary land and, like...
Yeah, so that's actually, I said that Māori land generally is few and far between. Customary land is even more. I actually probably, off the top of my head, couldn't say, a whenua or a block that is Māori customarily owned. I think there may be small pockets up in Takutai Moana and stuff like that could be urupa or have marae on them that possibly could be customary land.
How does it get that rating? Like, how does it get rated as customary land? Is there a...
It's generally not. Yeah, it's generally not. But that's like Māori Freehold land. It's been a huge struggle to get them unrated so that they don't accumulate rates anymore, which has been one of the big issues that we see, particularly within the Waitangi Tribunal with the claim issues, is that the land that was there, or as an example, some of Māori land is landlocked, so it's not actually accessible by those people that own that land, and it could be, 100 Māori landowners, but it's still rated. So the council send out bills to, whoever's on that land, but they maybe don't even know that they own that, they can't access it, they're not using it, but are still required to pay the rates on that land. So it's slowly starting to become an issue with the council that they recognise that some Māori land, not all Māori land, is unrateable and shouldn't be rateable. Yeah.
But what's the difference between, like, the property that I own and Māori land? Like, how does it...
Oh, it's on two different registers.
Right.
Well, and that's why we're saying with the customary land it may not be. Is that correct? Am I correct in making that assumption?
Yeah, so probably the biggest difference, if you're talking about, are you talking about like your whare and the general title? Yeah. So the biggest difference would be that the multiple ownership on the land. Most of Māori land blocks have, some have 565 owners or something like that, and it's apportioned into shares and interests, whereas one owner, like my whenua, I have interests up to Takutai Moana, I have 0.026 shares or something like that in the land. So the major difference between those two land titles is the inability to actually utilise that land, whereas with a general title or general land, you're usually only one or two owners, so being able to utilise that, make decisions on that land is much, much more easier.
And also, I think that what comes from that register, the general title, my understanding from, and I'm going way back to law school here, is that you actually had indefeasible protection, a guarantee that that land is yours, whereas there's some contestability on the Māori register, and that I always saw that as being almost like you don't necessarily get the same level of guarantee that you own that land. It's contestable. There's small ways to do it. It's not open slather, but whereas on the general register, it's once you're registered, that's it. You own it.
It's the Māori Land Court that governs Māori land, so it's totally different to how general title and general land actually runs and the laws that govern it. And like you pointed out at the start of our kōrero, Julia, Māori land is governed by the Te Ture Whenua Māori Act 1993, and one of the main purposes of that act is to keep Māori land within Māori ownership or Māori title, and that's why all the different clauses of the Act, the section of the Act, are supposed to be about promoting Māori land ownership and how Māori can utilise that. So when you were talking about the ability for people who own general title to say, yes, I own this land, and if they wanted to, they could sell it, and so forth and so forth. One of the protections for Māori land is actually stopping people to do that. Now, which might seem at the start, you're taking away my mana motuhake or my tino rangatiratanga, but it's actually a provision to keep that land within the whakapapa of that whānau or that hapu. Because what we've seen from the past, for a number of reasons, a lot of Māori whānau or hapu would have sold their land to other hapu or into Pākehā ownership, which has seen a lot of our Māori land go out of Māori hands. So that was one of the general reasons or the purposes for the Act, was to keep Māori land and Māori ownership.
Okay. And actually, probably the only customary land I can think of that I know of is up north. My own hapu up in Kaupare has a farm, Takanini Farm. And as far as I know, it is possibly the only one it's never changed hands. We've always owned it, and that's an example.
Waimarie koutou. Like I said, I couldn't think off the top of my head, which just goes to show that it is few and far between that we can say we have customary land in our ownership.
I can see a more practical problem, like if you've got 0.003%, like how do you get 500 people to agree on using something? Or like
exactly.
Doesn't that just undermine everything if you've got 500 owners?
That's
I can't
the
even agree with
question.
4 people. So.
Yeah. And that's one of the huge issues that you see within the Māori Land Court, and that the court have to face, especially when some of those owners are disengaged with their land, or they live overseas, or they don't even know that they are owners and interests in the land. How do you manage that? Which I think was one of the key areas that they were looking at with the reform of Te Ture Whenua Māori Act. Obviously, it didn't eventuate, and there's still issues that are still there, but you hit it on the head there, Ehua. That's one of the huge issues that we face in terms of trying to manage that land.
Because everybody has their own ideas too, and some of them, as you say,
but it'd be too difficult, so you wouldn't do anything. Well,
yeah, you end up basically locked in perpetuity.
Yeah, and that's why Māori Land Court and most of my colleagues, Māori lawyers, push for the creation of trust over Māori land interest and Māori land shares.
Oh, so how does a trust help?
Yeah, so let's actually, that's a good question. That's the topic of the day. So if we move on into the topic of the day of Māori Land Trusts, and obviously it's great, Josh has got lots of questions and so do I, but I think where we can start is what is a Māori Land Trust?
Kapai. There's 2 different categories of trusts through the Māori Land Court. I think they have about 6 different trusts, but 2 different categories. So the first one are trusts that manage the shares or the interests of individuals or whānau in land. So they just manage the interests or the shares. The other category of a trust is trusts that manage the actual land block or land blocks. So the first one, when they're managing interests or shares, is what's most common is the whānau trusts, and the ones that manage the land blocks are your ahuwhenua trusts or your Māori reservations. So those are the most common ones. Yeah, but those are the 2 kind of categories.
And I think even just understanding the difference in that makes it a lot easier to navigate. So how would you go about setting one up? Obviously, you'd go to your lawyer.
Yeah, so
hire Alana.
So the 2, they're very different, like I said, because the purpose is different. One manages shares and interests, and one actually manages the land. There's different requirements for both of them. So in terms of the whānau trusts, it's a bit easier. And essentially, they come about when you go through that succession process. Your kani or your koro, your kui, or whatever passes away. They've got interests in land, and so some whānau, not all whānau, go to the Māori Land Court to succeed to those interests. Now, instead of those interests or shares in that land further fragmenting down into smaller shares and smaller shares, what the Māori Land Court tend to advise is that whānau would establish a whānau trust. Now, the whānau trust, like I said, deals with the management of the interests. So say Miriana was my kani, and I want to find all the interests she has in land blocks. So not just talking about one land block, but every land block that she may have, Te Waipounamu, Waikato Maniapoto, having a look at all her interests she has and putting them into one trust. Now that whānau trust would then be, as an example, called the Miriana Pārangi Whānau Trust, and the beneficiary of all her descendants. And then all those interests, all those land shares would be put into that trust and managed by the trustees. So you would appoint trustees for the beneficiaries of all her descendants. So if the trust stayed alive for, say, 100 years, and you've got 2 or 3 more generations, it's anyone that can whakapapa to that common tupuna would have an interest or be a beneficiary to that trust. And like I said, the main purpose or the main benefits of establishing that whānau trust is those 0.05 shares or whatever you had don't go down and get further fragmented. They stay at that 0.05 share or whatever in your kuia or your kaumata or your tupuna's name. And obviously the most important thing is to appoint the right trustees to look after those shares and how they can manage them for the betterment of all the beneficiaries of that trust. Like I said, that's usually done when someone passes away, and instead of succeeding to those shares, a whānau trust is made up instead. But you can also do it when people are alive. So if Julia today wanted to go out and establish a whānau trust over the interests you had, you could do that too. You know, you just go to the Māori Land Court and say, I want to bring all my interests together and put them into one trust, and I want to be the tupuna or the name, and everyone that will whakapapa to me for, ever can be beneficiaries too.
So that's an interesting one when it comes to, say, if I have interests in particular hapu and their trustee says, and that's because I whakapapa to the tupuna of, say, whatever that hapu is, and then I create one, but I adopt or whangai rather than even adopt, but the head kind of deed above that I whakapapa to doesn't recognise it. It's almost like too bad because they whakapapa to me if I include them in my beneficiaries. I know I've come up with a very complicated scenario, but actually why I'm saying that is because I do know there's quite a few whangai is one of those topics across the motu that is quite touchy because some of them recognise them and some of them don't. And this is potentially a way to still allow your whangai offspring to benefit when you're gone from that.
Yeah. And I think essentially, whangai is a big issue, eh? And I don't think there's just one legal test for what is a whangai. There's been a lot of case law and development within the Māori Land Court about when a whangai is whangai or when, they're not in terms of tikanga. And, you and I will both know that the tikanga of whangai will change from different iwi to different hapu to different whānau. So for the Māori Land Court or the Māori law jurisdiction to say this is a whangai and this is when they'll be recognised as whangai is too hard to do. So what they've developed over the years is a list of criteria for court to consider or trust to consider or trust orders to consider, but at the end of the day it will come down to the tikanga of that whānau or that hapu. But yeah, certainly what you were saying would be interesting to see if you and your whānau trust decided, yes, this is my whangai and they would be a beneficiary under my whānau trust. Then would that be recognised under, say, the Ahu Whenua Trust order which your whānau trust would come under. That's what you're getting at, eh?
Yes, yes. You said it much more eloquently than I did. So I was lucky you caught what I meant. So if we move then to the Āhua Whenua trusts, which is pretty much where things like farms are being managed?
Yeah, so like I said, the Āhua Whenua Trust, which is the most common, is to do with the land, so it's managing the land. So the trust would be established over a whole block, rather than like the whānau interest, it's just small interests or shares within a particular block or many different blocks. The Āhua Whenua Trust is over the whole block, and it's just one block. So, you know, just as an example, again, I'll pull up my own. Te Ti is the name of the block, and that would be managed under an Āhua Whenua Trust, who would then have trustees appointed which managed the block itself. So like you said, that's really beneficial for blocks that have farms, that need a governing body to look after those issues. The one thing with Āhua Whenua Trust, though, is that everyone who has a share or an interest in that block, when you first want to constitute or establish an Āhua Whenua Trust, have to agree that, yes, this is what we want to do. Now, once again, the same issues come up that we were speaking to Josh about, is what about those people that are disengaged? They don't agree, they don't understand, all that kind of stuff. So that issue of disengagement is prevalent in most of the kaupapa. What the Māori Land Court has had to recognise is that, look, it's just a reality that you're never going to get 100% consent to these issues. So where's our threshold? If you want to establish Āhua Whenua Trust, is it just 50%? Is it 60%? You know, where's the threshold for you can go through with this kaupapa? So Āhua Whenua Trust is usually a majority, but the Māori Land Court look at issues of why there may not be engagement, you know, and so they take that into consideration.
Is there a threshold?
It varies. It varies. I think with the Āhua Whenua Trust, it's 50%. It's, you know, half of those agree that this is good. 60%, or I'll have to check that one, Josh.
Yeah, that's all right. But if you can get a lot of people to agree, then it doesn't have to always be 100%.
Yeah. And even that would be a push, I would imagine, 50, 60%.
Yeah, and like with some, it's easy because some lucky land blocks don't have, 500 owners. They'd have maybe 20. And it's much more easier, and sometimes they're all whānau. So, they talk, they get along. Well, what is that one Māori whānau that gets along?
Yeah.
And it's easy to come to decisions like that, to do that. But the reality is a lot aren't like that too. And that's why the Māori Land Court is different in how they look at all those other issues about why and how you make decisions with Māori land.
So who can be a trustee? Do they have independence, or do they all have to be whānau?
Essentially.
Let's just look at the Āhua Whenua example.
So with Āhua Whenua Trust is, I don't like to say more important than whānau trusts, but the reality is you're probably going to be dealing with more
higher value assets,
corporate issues, rather than a whānau trust. The whānau trust is this management of issues, interests, attending hui, and probably, voting on issues on behalf of your whānau. But with the Āhua Whenua Trust, you are dealing with utilisation of land issues. So you would want to, I would like to think, as a trustee, you would want to have the right skills and the ability to effectively manage that land. So really that's the only thing they're looking for, the Māori Land Court and or your beneficiaries, your trusts, looking for someone who can do that. But obviously there's some things that will bar you from being a trustee, just like the usual trustee rules and duties that, can't be bankrupt or convicted of a crime of dishonesty. A minor obviously can't be a trustee. You haven't been removed from an actual trust before, so having a look at your past and your history in terms of these kind of tūranga. Yeah, so that's the only things that really bar you, but really just looking at your skills and your expertise to be able to manage the issues that trust would manage.
And you really need a mix of skills on those as trustees. And what I have experienced is sometimes there's there hasn't been great succession. So you've got perhaps some trustees that have been there a long time and possibly didn't have, dare I say, the skill set to start with.
Yeah.
Not saying that they don't bring something to it, but I think that is one of the issues that is facing a lot of these trusts, is that there's no succession, and two, there's not a lot of thought put into the skill set required.
But where would you go for training for things like that?
There's a whole lot of governance training out there that you can do.
Is that what the trustee governance training?
Yeah, yeah.
And the Māori Land Court themselves, the Māori Land Court have, I think in the past, I want to say maybe the past 10 years, have started doing their own trustee training for Māori Land Trust, because they, I think, saw exactly what you just pointed out, Julia, is that there may be the best intention to have a trust or to manage or to utilise your land, but without having the right people sitting on that trust with the level of expertise that's required, we've seen that sometimes those trusts get into trouble, which, is not their fault per se, but it was just for those people who got appointed. We just didn't really know, what was a trustee's job? What am I supposed to do? So the Māori Land Court recognised that, and they provide trustee training specifically for Māori land and Māori trusts, which is really, really good. And I think they have some really good pamphlets and information on what you should expect to do as a trustee on a Māori land trust.
And as you say, sometimes it's just like, well, some of them didn't even want to be trustees. It was like, well, you're going to be on this trust. Oh, okay, Nanny.
Yeah.
So
or it's whoever showed up to the hui, eh?
Yep. Sometimes it's
and their name's put down, and all of a sudden you're a trustee on an ahu whenua trust that manages like this $1 million farm or something like that.
The trustee duties, once you're on a trust, and then you've got different types of trustees. Some are whānau trustees, and sometimes they bring in independents. And I guess it all comes back to what is in the trust deed as well, which is an area I really want to focus on. And I think we should start talking about the trust deed, because I don't think people quite understand the importance of a trust deed in setting out really transparently how it's going to work. And when it's all smiles when it starts, but you really need that deed to be quite robust for when things happen or go wrong.
Yeah, absolutely.
So what are the kind of essential parts of the trust deed that you think are really key for Māori ahua whenua trust?
Kaupare, so I think you hit it right on the head, Julian. It's real lawyer talk, eh? It's all nice and roses at the beginning, but, it's our job to think about when things aren't so rosy, and what if this happened, and what if this happened? What do you do when, you get into a bit of strife or some issues and problem? And that's the first stop, is going back to that trust order or that trust deed, because essentially everything in there is how you deal with issues. And if a problem comes up, this is what you do. So it's your Bible, yeah? So the first thing that needs to be in a trust deed or a trust order is what is the purpose of your trust itself, whether it's a whānau trust or an ahu whenua trust. What is the purpose, and what's the objects? What are you trying to achieve for your beneficiaries or for the land? With whānau trusts, they're usually pretty standard for the betterment of the descendants of whoever that tupuna was. And they try to give out, if they have any money, most whānau trusts don't actually have money, but, to better their education, employment, if they can. Those are fairly easy. But the ahu whenua purposes might be a little bit different. And it's within the ahu whenua trust order where you really see what the powers and the duties of the trustees are. So any kind of advice I would give to someone who was considering being a trustee on an ahu whenua trust or a whānau trust is to really have a look at a template or an example of a trust order, because everything is outlined in there about what's the expectations of a trustee, what they should be doing, what's their powers, but also what's their limitations and what they shouldn't be doing as well. So that's, having a look at any conflicts of interest you might have, your financial management duties, down to duties just to call meetings and how those meetings run and how decisions are made. Everything is set out clearly, or should be set out clearly, in that trust order, which is why I said, it's a trust's Bible, it's your go-to. And if there's any questions about anything about how you manage your trust, should be in that trust order. Yeah, and so probably after the powers of a trust, like the trustees, what can they do, is the importance of setting out in a trust order how you have your meetings. And what I've seen within the Māori Land Court is this is probably one of the areas where issues get contested, or there's room for people to argue, or no, that didn't happen at the meeting, that's not the decision we made because we didn't follow blah, blah, blah clause in the trust order. So really detailing, how a meeting's going to be held, from there should be 3 weeks notice in the Pāpokero or the Northland Advocate paper, because that's the paper that's closest to the land. The notice should detail exactly what the meeting's about. There should be a quorum of, however owners should be there, everything detailed exactly of how a meeting's going to run. And that includes all your proxies and your voting and all that kind of stuff.
Yeah. And sometimes even just getting the quorum is hard. But one of the things that I've seen asked about from my own whānau, and I'm lucky enough to say, look, I don't practice in that area, but one of the things is, like, they always ask about, how do I remove a trustee? So it comes down to sort of, and if there's disputes between the trustees, and I think if there is a process in the trustee, it would be so much easier, because then you literally just follow that process.
Yeah.
So how do you get rid of someone?
Again,
how do you get rid of someone? So it's essentially up to the trust order. So exactly what Julia said, that process of appointing a trustee, re-electing a trustee, removing a trustee, their term of office, everything to do around that process should be set out in the trust order. It'll differ from trust to trust, but a general, and like I said, it will differ, is a trustee will remain on for a rotation of maybe 3 years, and then they'll come up for re-election at an AGM, and they can either stand down or not want to be, or be re-elected onto that. If you have a trustee that hasn't been attending consecutive meetings, for example, that can be a reason that they be removed. And you'll, be surprised to know that some trustees still sit on a trust when they have been passed away, and they're still on there for like years. So that just is an example of how well that trust is managed, I guess. And then if the trustee is generally acting not in the benefit of the trust, they start doing some not good things, then those are reasons, obviously, for their removal, and the trust itself would apply to the Māori Land Court to have that person removed.
And you'd have to have good evidence. I think that's one of the key things to understand. You have to have good evidence to show the court that they're not doing right by the trust. Yeah,
exactly. And it's not, they're not acting within the purpose and the object. So like we talked about at the start of the trust deed would list what the purpose and the object of that trust actually is. And if the trustee is not trying to work for that purpose or that object, then, that's good reason to have them removed. Or if they're just being generally a obstacle to the betterment of that trust, then those are reasons too. But yeah, like Julia said, you'd have to have good evidence for that, because it's a huge thing to have someone removed.
And it's easier said than done, really.
No.
And also, whānau-wise, it's easier said than done, because quite often they'll
still related
pretty forgiving, a lot of whānau, and they go, oh yeah, they did that, but they won't do it again, they've said. So
yeah, absolutely, and that's right. So some of the issues that are actually happening within a trust sometimes won't actually make it to the Māori Land Court. So the Māori Land Court may not even know that that's happening within that trust, because whānau are, like you said, easy to forgive, and Kaupare took a bit more money out of the bank than he told us, but which is not great, but it's happened before, and that's the reality. So that's why we need to put all those checks on who actually is becoming a trustee, and do they understand their obligations and their duties.
I was just interested, as a lawyer for the trusts, what do you see that frustrates you, and what do you see that's like excites you, or that you see as wins?
On the Māori Land Court and through the Māori Advisory Services, they provide templates on what a trust order can look like, which is really, really helpful, because most of us don't know, well, what should actually be in a trust order, and all that kind of thing. So they provide you templates when you are establishing a trust. But for me, what I say to my clients, and most of us are becoming really astute these days and legally minded and want to know or do know a lot about legal issues. So what I say is, look, this is a template only, but take it back to your whānau, whoever your shareholders, your beneficiaries are, have a hui to see what would actually work for you. Because more and more these days, we're looking at how tikanga Māori and Māori concepts can work hand in hand with law. So the templates and the orders that are provided by the Māori Land Court, they follow the legal requirements of a trust. But what are other issues that are really relevant to your whānau, to your hapu? What's some of that tikanga that you can bring into that trust order so that it works for you? Sometimes we get into trouble, we get into daru because we're trying to follow a system that doesn't quite align to our concepts and our ideas. So having that, knowing that you actually have the ability to play with that template and to create your own trust order. And most of our people don't really know that. So I'm working with some clients now who have a big block up north, and they're redoing their trust order. And while they're following the same guidelines that's provided, they're in certain areas which actually work more for them, and they're actually doing all of their trust order in Te Reo Māori. So it's having that ability and knowing that you have that ability to change that trust order to fit you and how you as a Māori manage your land.
What about the things that you work on, or the cases or examples that you work on where you feel like, man, this is why I do what I do. This is a great outcome, or I love to see this happening.
Kaupare, so, and me pono taku kōrero, it's probably not a legal outcome, but a lot of the times when you go to the Māori Land Court and you've got parties against each other, they're, by and large, most of the time they're whānau, yeah? Sometimes it's brothers and sisters against each other, cousins, aunties, uncles, brothers and sons, that kind of thing. They're not just, someone down the road that you don't really know much from your hapu. They're people within their whānau who have really serious issues and fighting with each other over this land. So for me, I think the Māori Land Court's not just, dealing with these Māori land issues, but really it's a place where our people can get together to have more of an understanding of what they're doing. And at the end of the day, if we can bring those people together, he pai ngā tutera. So, I've been involved with a few cases where it's really hit the fan within the court, and people have actually been ordered out of the court, police called, and that kind of stuff, just because the passion. So the ultimate, my woohoo moments that I have is coming to an end of a court sitting. So you get into an outcome within the Māori Land Court where all parties feel like we've got into a place where we can move forward together.
Yeah. That must be really satisfying, actually. Because would you go as far as to say as there have been healing moments within whānau?
Yeah, absolutely. The trust issues are one of the big things in the court, and actually, because you talked about it before, Julia, one of the other kind of contentious issues is the place of whangai within succession applications, and Māori people, when they pass away, who do their interests go to? And it's not just about the interests of that land, but it's actually the recognition of whangai or of other tamariki, recognition of them as their children. So sometimes they come to the courts and they talk about, look, I don't even want interests, I don't want the land. I just want you guys to recognise that, I actually was his child or her tamaiti or something like that. So it's, I think it's absolutely healing moment, and having a look at that whole space for a whānau or a hapu to move forward together. Yeah.
So do you have any tips for listeners? And it doesn't have to be legal.
Actually, this probably goes against my what I should be saying, but with Māori Land Court stuff, you actually, for the easy stuff, don't need a lawyer. Some people,
wow.
you don't need a lawyer. Yeah, I know.
Cool.
So I get, a lot of phone calls that say, can you help me with the succession application? And most of the time I say to them, look, lawyers are so expensive, you'd be better off just popping into a Māori Land Court office, and they have advisory services there that are so helpful and give you all the information that you need, and you don't have to pay for that. It's just a free session at the Māori Land Court. They provide those services for you. They have template applications. They let you know exactly what you have to do. So if it's just easy stuff like a succession application, finding out interests, transferring them over to somebody else, my tip would be just to ring up the Māori Land Court yourself and see if it's something that you can do, if you're comfortable with doing. But if it is a little bit more complicated, then yes, absolutely ring a lawyer then.
Yeah.
You're generous. You're generous to share that information.
I know.
Well, I think, kia ora, ngā mihi nui kia koe, because I think that if there's bits that you can let people have for free, I think that's really important, because it is the harder stuff where you know that that's why you're charging the rate you're charging, right? You're not charging a rate so you can fill out, right? You're not filling out a form for them, right?
But we've got to give Alana a chance to say, what should people come to you for? Like, what's some examples of some things where they should come to a lawyer?
I think certainly with trusts, if you're thinking of establishing a trust, to have a chat with a lawyer, just because, especially the trustees, so that they understand what they're actually entering into. But even then, there's still awesome information in the I'm really plugging the Māori Land Court, aren't I? Still really good information at the Māori Land Court, so that kind of stuff. And then the other time that you would see a lawyer is if something bad has happened within the trust and you're really not sure what to do, and you need a bit of legal advice on how to move forward, then I would have a chat with a lawyer.
Great. That's a great tip of the week, Alana. Thanks again to our guest, Alana Thomas, and to my co-host, Josh Brown. And don't forget to subscribe to make sure you get the shows as they come out. Until then, I'm Julia Stenson from all us here. Take care. Have an awesome day. Kia pai tō rā.